Hi, I'm Brad Hennings, a partner at Chisholm, Kilpatrick, and today we are coming to you from our Houston, Texas office. I'm joined here by my colleague, Dallas Aguiar, an accredited claims agent at CCK. In this video, we will be discussing tips and strategies on maximizing your veterans' disability benefits, starting with a quick overview of the VA benefits process.
Veterans with disabling conditions related to their military service may be eligible for compensation benefits from the Department of Veterans Affairs. To receive compensation or VA disability benefits, veterans first need to file a claim.
To qualify for VA disability compensation, veterans must establish service connection for their condition. VA grants service connection to veterans who have evidence that their disability is, at least as likely as not, connected to their military service. While there is more than one way to prove service connection, it generally requires the proof of three things.
The first being an in-service event, injury, or illness. Second, a current diagnosis by a medical professional. And third, a medical nexus or link between the in-service event, injury, or illness and current diagnosis.
So initial claims can be filed using VA Form 21-526-EZ. There are 4 different ways to file this form or another claim form with VA.
You could file online by using va.gov, by mail by printing, filling out, and sending the form to the Department of Veterans Affairs Claims Intake Center, in person by bringing the completed form to the nearest VA regional office, and finally with a legal representative by completing the form with the assistance of a Veteran Service Organization or VSO, or a VA-accredited attorney or agent.
Generally, filing a VA claim online is the fastest and most convenient way to apply for disability compensation. Electronic records can be processed using a variety of automated tools, allowing VA to complete certain tasks with greater speed.
And something the VA will typically require during this process is a C&P exam. C&P exams, which is short for compensation and pension exams, are performed by a VA contracted provider. The exams are used to confirm or deny service connection and or establish the severity of a veteran's disability.
That's right, Dallas. Since medical evidence is crucial to a veteran's disability case, C&P exams are provided by VA at no cost to the veteran as part of VA's duty to assist. As VA adjudicators put significant weight on C&P exams when deciding claims, veterans should always attend any scheduled C&P exams or reschedule as soon as possible if they cannot, and be sure to request a copy of their exam report.
Now that we've gone over a quick overview of the VA benefits process, we will be discussing ways to increase chances of a favorable decision and how to attain the highest deserved rating.
One way to attain a higher rating is to file for secondary conditions. A secondary service-connected disability is a disability that resulted from a condition that is already service-connected.
And in these claims, providing a nexus or link between a veteran's secondary disability to their already service-connected disability is extremely important. The nexus between your primary disability and your secondary disability must be clearly established to be granted secondary service connection for the claimed disability.
That's right, Dallas. Now, there's a number of common secondary conditions, including depression and anxiety, peripheral neuropathy secondary to diabetes, hypertension secondary to PTSD, and erectile dysfunction secondary to prostate cancer, among many others.
And to learn about others, check out our website at cck-law.com. Another way to attain a higher rating is to file for TDIU.
TDIU, or Total Disability Based on Individual Unemployability, is a VA benefit available to veterans who are unable to work due to their service-connected condition or conditions. Specifically, it allows for veterans to be compensated at VA's 100% disability rate, even if their combined scheduler rating does not equal 100%.
And there are 2 types of TDIU a veteran may be awarded, scheduler and extra scheduler. And we have more extensive information about TDIU on our website.
This next tip may seem obvious, but it's incredibly important that veterans use the correct form or forms when filing a claim for disability benefits. VA has numerous forms veterans can use depending on the specific action they want to take with their claim. Using the correct form avoids confusion on VA's part and minimizes delays.
Definitely, Brad, and we see this all the time. So it's super important to pay attention to which form you are filing. Some common forms are
VA Form 21-526EZ, which is the application for VA disability compensation and related compensation benefits to apply for VA benefits. VA Form 20-0995, the Decision Review Request Supplemental Claim. This is used to file a claim that was previously denied. It can also be used to continuously pursue a denied claim within a year of your decision.
And there's also the VA Form 21-8940, Veterans Application for Increased Compensation Based on Unemployability. This form is used when seeking TDIU benefits.
And VA Form 21-4138, Statement in Support of Claim, which can include lay evidence such as buddy statements to support your claim.
We have a blog on our website that covers the 7 most important VA forms and how to use them. If you're interested, check out cck-law.com/blog and search 7 most important VA forms.
The next thing we wanted to discuss is submitting sufficient and relevant evidence. Gathering and submitting sufficient evidence is crucial to building a strong claim. Including all possible evidence in your initial claim can reduce decision time, as this means that VA will have all the information it needs to make a decision.
Some evidence veterans may want to submit include medical records, such as your private medical records, in-service medical records, reports from VA medical centers, and CMP exam results. A veteran may also want to submit service records. Now, VA should obtain these records as part of their duty to assist, but in case they're unable to locate your service records, you can submit your DD-214, service medical records, and service personnel records.
Employment records are also important to include. These can become a necessary piece of VA claim evidence if a veteran is seeking entitlement to TDIU or an increased rating. Veterans can fill out VA Form 21-4192, which is used by VA to gather information regarding a veteran's past or current employment, or you can submit any record of disciplinary action or performance reports.
Another thing to include would be lay statements. Lay statements are written statements from a veteran, family member, friend, or coworker that can be used to submit in support of a veteran's claim. They can be especially useful to document and report symptoms and frequency of symptoms a veteran experiences to support a claim for an increased rating.
Buddy statements, those written by a fellow service member on behalf of a veteran filing the claim, can be useful to corroborate an in-service event or injury. They can also be used to testify to observed level of impairment a disability causes. Veterans can use VA Form 21-10210, the lay/witness statement form, to submit these claims.
However, it's important to avoid including evidence that is not relevant to your claim. Doing so can make it difficult for VA to locate the pertinent evidence that is most relevant to the claimed condition, and this could hurt your claim. If you're interested in more information on evidence to provide along with your VA claim, visit our website at cck-law.com/blog and search what evidence will the VA require.
The next topic we want to discuss is how navigating the appeals process works. If VA denied a veteran's claim for disability benefits, the veteran typically has 1 year from the date of the rating decision to file an appeal. This also ensures that their effective date remains in place.
And a veteran's effective date is the date which VA uses as a start date to pay the veteran disability benefits for their claim. The effective date essentially determines how much the veteran will be entitled to in retroactive benefits.
All claims decided after February 2019 are processed under the AMA system. AMA, which is short for the Appeals Modernization Act, is the law governing VA's appeals process since 2019.
Claimants seeking to appeal an unfavorable VA decision must choose one of the following 3 review options, which are also known as lanes. There's the higher level review lane, in which a veteran is requesting a review of a current claim by a senior VA employee. And there's the supplemental claim lane, where a veteran can submit new and relevant evidence as part of a supplemental claim. And finally, there's the notice of disagreement lane, where a veteran can file an appeal to the Board of Veterans' Appeals.
Now, what some of you might be wondering is what happens if your appeal is denied? If a veteran receives an unfavorable result following their appeal in the AMA system, they have the option to continue the appeal.
If a veteran receives an unfavorable decision in the higher level review lane, they have 1 year to file either a supplemental claim or a notice of disagreement. And if a veteran receives an unfavorable rating decision in the supplemental claim lane, you have 1 year to file an appeal in any of the 3 available lanes.
If a veteran receives an unfavorable Board of Veterans' Appeals decision, they can either file a supplemental claim within 1 year or appeal to the Court of Appeals for Veterans Claims, the CAVC, within 120 days. If a veteran receives an unfavorable decision from the CAVC, they have up to 1 year to file a supplemental claim or 60 days to appeal to the Federal Circuit.
The VA claims process can be confusing, but it's important not to give up on a claim, even if the process seems endless or you've been denied. Veterans who feel they need assistance should remember that help is available. VSOs, accredited representatives, and accredited attorneys can assist with a claim or appeal.
Absolutely, Dallas. The skilled team at CCK has recovered over $1 billion in benefits for disabled veterans since 1999. We have extensive experience advocating for veterans at all stages of the claims process, including representing clients at both the Board of Veterans' Appeals and before the Court of Appeals for Veterans Claims. Contact us today for a free case evaluation to see if we can assist.